Judge Aileen Cannon denying without prejudice Trump's motion to dismiss counts 1 through 32 in his classified documents case. Her ruling coming in just moments ago. She said Trump's arguments were better suited to be argued later on in connection with jury instructions or with other motions. In other words, she punted the decision. It comes after Trump and Jack Smith faced off in a federal courtroom in Florida today. Trump's attorneys arguing to dismiss the entire superseding indictment against him, claiming that the Presidential Records Act gives Trump the authority to take and claim those classified documents as his own personal property. In their motion, Trump's lawyers wrote, President Trump exercised virtually unreviewable authority to designate the records as personal. In court, Trump lawyer Todd Blanche arguing, quote, presidents since George Washington have taken materials out of the White House at their own discretion. The DOJ quickly shooting back. The documents charged in the indictment are not personal records, period. They are nowhere close to that. Remember, Trump allegedly had nuclear secrets stashed away in some of those boxes. The DOJ emphasizing the gravity of the whole scenario. Quote, there has never been a situation remotely similar to this one. But those weren't the only arguments presented by Trump's team. They also resurrected an old favorite. But her emails, arguing that Hillary Clinton wasn't prosecuted, so Trump shouldn't be either. I should note, the FBI found that Clinton never discussed any classified material in the emails on her private account. Meanwhile, Trump's defense in public seems to be, if you say it enough, it must be true. Because speaking to Newsmax last night about these documents, Trump readily admitted he took them.
I took them very legally, and I wasn't hiding them. We had boxes on the front of and a lot of those boxes had clothing and we're moving out, okay? Unfortunately, we're moving out of the White House. I had the right to do it, in my opinion, and in my lawyer's opinion and everything else.
Joining me now is Christy Greenberg, former federal prosecutor with the Southern District of New York, and now an MSNBC legal analyst, and Emily Bazelon, legal writer with the New York Times Magazine. My thanks to both of you for getting us started this evening. Christy, that was a pretty fast ruling from Judge Cannon. I mean, she said she was going to rule promptly. We didn't expect it to happen just a couple of hours after court recessed, but Cannon, frankly, didn't really decide anything, right? I mean, what are your thoughts about this ruling?
Right. She dismissed the motion that Donald Trump made that essentially the statute is too vague. The Espionage Act is too vague as it is applied to him. And Judge Cannon in her order says, well, there are still these fluctuating definitions of statutory terms and the phrases as charged. It's like, what is fluctuating exactly? The statute's been applied over and over again. There are decisions on it. This isn't an area of law that's completely new. There are decisions here that tell you exactly what the terms are. And Donald Trump, it was explained to him from lawyers exactly that he could not keep these documents. So I'm not really sure what she's talking about as to why this is vague. It seems like this is a motion that could have been decided on the papers. But you're right, Katie. Look, she just punted this down the road, kicked the can down the road, which seems to be her MO in this case.
And Emily, you know, there's a lot of us scratching our heads as to why, and Christy just mentioned it right now, right? Why either of the two motions that were filed by Trump, the Presidential Records Act and the unconstitutional vagueness motion, why they even deserved oral argument in the first place. Do you think Judge Cannon is getting on-the-job training here?
You know, I think to be generous to Judge Cannon, she's trying to show that she's taking arguments seriously. She talked about that idea that these were serious arguments. And I suppose once you decide that, then you want to hear from the lawyers on that question. I think it's important to just emphasize how broad an argument Trump and his lawyers are making here. They are saying that as the former president, if he said that a record was personal, then he had the power to decide that, and that is not really something the courts can review. And so that seems to suggest that former presidents get to decide at the end of their tenure what to keep and take home with them and what the government gets to have. And that is really hard to square with the language of the actual statute here, which was passed in the wake of the Nixon administration to make sure that presidential records remained part of the public record and with the federal archives, not in the boxes in places like Mar-a-Lago.
In the Mar-a-Lago bathroom, to be specific for some of them. Christy, I want to switch gears because I love that we have you here this evening, especially the New York DA Alvin Bragg, filing a notice this afternoon, late afternoon, supporting a limited 30-day delay in the Trump hush money trial. It would give Trump's lawyers time to review a new batch of voluminous documents that have been provided in discovery. Trump's lawyers are actually asking that the trial be delayed 90 days, but they're also wholesale asking for a dismissal. Christy, I have to ask you, you spent a lot of time at the SDNY. What's your reaction to this filing of the notice from Alvin Bragg?
I'm really confused. I think there are a lot of questions here. According to this filing from Alvin Bragg more than a year ago, he asked for the full grand jury record relating to Michael Cohen's campaign finance convictions from SDNY. That included grand jury materials, subpoena materials, search warrant returns. Really, he asked for a lot of this information. And SDNY produced a subset of what he requested, and they produced that, as they should have, back in June of last year. Now, in January, Donald Trump serves a subpoena for apparently a lot of this same material. And in March, a few weeks ago, SDNY produced some materials that largely Alvin Bragg says are irrelevant, other than maybe a few hundred pages of witness statements that are relevant. But then yesterday, they produce another 30,000 pages of documents. And Alvin Bragg says, this is what I asked for more than a year ago. So there are real questions as to why, if he asked for it over a year ago, it's getting produced less than 2 weeks from a trial date. And that's not all. SDNY apparently has also said they have more to produce and that they are looking to make a production next week. Well, this trial is scheduled for the 25th. You cannot be producing documents on the eve of trial. This Cohen prosecution happened in 2018. There is no reason why they should be producing documents on the eve of trial. I think there really needs to be an explanation here. And just one more point. We say all the time that Donald Trump's tactic is delay, delay, delay. And that is largely true and largely frivolous. In this situation, Katie, as you know from being a prosecutor, you don't want to be in a position ever where you're producing documents on the eve of a trial that both the prosecution hasn't gotten an opportunity to review and the defense hasn't had an opportunity to review. So again, this doesn't seem like it's Alvin Bragg's fault. He produced what he had in his possession, but it's a real question as to why he didn't get these materials sooner.
Yeah, Emily, to kind of use that as a springboard, what Chrissy just explained, Bragg in his notice also talks about the fact, though, that delay should be attributable to Trump because Bragg turned over thousands and tens of thousands of documents last year, but it was only until mid-January of this year, just shy of 60 days going to trial, right, that a subpoena was served by Donald Trump on the U.S. Attorney's Office, Southern District of New York, to get these documents, some of which it sounds like, according to Christy, and I would agree, there's a huge overlap there, right, from what was turned over in production last year and what was subpoenaed. But why is it then that this possible delay, which is going to be another win for Trump, you know what, the way I look at it, though, a little bit, Emilio, it's still a state prosecution, though, right? It's not a federal prosecution. So maybe it doesn't go to trial this month, but maybe it goes to trial next month, still in advance of November.
Yeah, that's entirely possible. I mean, I do think there's a pattern here where you're seeing the legal system tie itself in knots in some of the prosecutions of Trump. Yes, his lawyers and Trump desperately want delay and they are scoring wins. It is also true that in some cases we've seen the prosecutors or the judges also seem either in the name of being very proper about due process or because of what sounds like a kind of set of unanswered questions about why the Southern District didn't produce these documents earlier. It starts to seem like the legal system is part of the problem, and that is troubling given the stakes here.